सिग्नल ही नहीं आ रहा यार। Uh, Thankchan,
Yes, yes.
we have, I think we have just 1 minute left. I'm waiting for Sir to connect.
Sir. Oh, okay.
Your Lordship has not
I
connected
think
as
sir
far
didn't
as yet.
come.
Pardon?
Okay. Yes.
तो म्यूट कर दे यहाँ गए इधर गए इधर लोग के बटन पे क्लिक मारा
So Sir is here. Hello, Sir is here.
Yes.
मैगजीन रिलीज होने
Hello. So shall we start?
वाली अभी और
Let me unmute him.
Sir is here. Your Lordship is here. बहुत unstable connection है यार, shit.
Yes.
It's okay?
Let me unmute your lordships.
Yeah, your Lordship.
Yes. 1 second. Let me unmute the lordship.
Yeah, it's Acer
I
iPad.
can't find his name, Sir Sachin.
Yeah, it's, I think,
I cannot find his name.
Sir, your is Acer iPad? Yeah, Sir is Acer iPad. It's like Acer's iPad. Its Lordships is there. Next to
Okay,
Nina Khare.
Let me 1 second. Okay. Yes. 1 second. Oh, yes. I see. Yes.
Son?
Sir, please unmute yourself, sir. Yes.
Yes, sir. Thank you, sir.
Mr. Jain, can you hear me? Are we on board?
Yes, sir. Yes, sir. So I'm on board. You're also on board, sir.
Okay, that's nice. That's
Thank you.
Mr. Pankaj Chand, I believe.
Yeah, I'm Mr. Thankachan, sir.
Okay.
Yes.
So shall we start?
Yeah, I'm okay.
Okay, sir. So a very good evening to all. Thank you for joining. Today we all are here, present virtually for a very august moment on 1st of August for a web release of our third edition of e-magazine, e-mediation writing, which is finally acknowledged as EMW. It is the first ever unique concept of its kind, started by Pan India and international mediators, with special reference to Judge Halim from Bangladesh, Madam Sharanjeet from Singapore, to create an e-library of articles on mediation. As we all know that mediation today is accepted as best mechanism of dispute resolution in India and abroad. The day is not far when we will have enactment on mediation very soon. Our chief guest for today is Honorable Mr. Justice Gurmeet Singh Sandhawalia, Judge, Punjab and Haryana High Court, Chandigarh. Sir, I welcome you on behalf of Team EMW and thank you for sparing some time for us.
Thank you.
I also welcome Justice Kanan, our patron, AJ Jawad, a mediator trainer, Sir Nand Gopal, Madam Nina Khare from Jabalpur, Gagandeep Kaur Singh, Director, Mediation Center, Punjab and Haryana High Court, and all other dignitaries here. Justice Sandhawalia has been a member of Mediation and Conciliation Committee of Punjab and Haryana High Court for last 7 years. Ever since, Sir has embellish the chair, he has been very proactive in promoting and referring matters to mediation center of our High Court. Sir's contribution to promote mediation in High Court can be demonstrated from the fact that he is very frequent in visiting the mediation center along with his brother and sister colleagues, taking a round of the center, briefing his colleagues about working of the center, appreciating litigants who have chosen mediation for resolution of their disputes. Sir, even at times, sit with parties which boost confidence in the parties and establishes faith and trust in mediation. Sir and Mediation Committee of Punjab and Haryana High Court has duly recognized and acknowledged the role of mediators who spend their valuable time for a social cause by raising the honorarium, which is second best in the country after the national capital. Every month release is followed by a topic of a day. Since we have primarily court annexed mediation, role of referral judges is of great importance and significance. Keeping this in mind, the topic of the day is role of referral judges in promoting the concept of mediation. I'm happy to share that we are going to introduce a new segment, Takeaway Window, which is sharing of life experiences by the mediators while doing mediation, simply because practical implications teaches us more. Now, I would request Sir to formally release the third edition of EMW and this new segment as well, and to say a few words of encouragement for this initiative. I would now request Mr. Thankachan, senior mediator from Kerala, to display the third edition page so that it can be formally released by the sir. Thankachan.
Thank you, Sachin. Honorable Justice G.S. Sandhawalia, sir, editor of this unique magazine, Pushputta, the moderator of this program, Sachin Jain, Punita Sethi, Monica Jalot, and other lawyers and mediators that participate in this program. Good afternoon to all. As already told by Sachin, this is the third edition of mediation rankings. It has been widely accepted by the mediators and lawyers all over India. But it should reach all the law colleges in India so that we can cultivate the seed of non-violent dispute resolution in the mind of the younger generation. And with your let me show the few pages of our e-magazine which I have created in PowerPoint. Thank you. Yes. Thank you. Thank you.
Thank you, Mr. Kankanchan. That was a very different inauguration, I must say. One is used to cutting ribbons, but this, by opening the strings on this e-technology method, you have evolved a new concept altogether. We have to congratulate you and Madam Bush Gupta also for this unique method. We wish you all the best and success in the future. Thank you, Mr. Kankanchan. That was a very different inauguration, I must say. One is used to cutting ribbons, but this, by opening the strings on this e-technology method, you have evolved a new concept altogether. We have to congratulate you and Madam Bush Gupta also for this unique method. All the best and success in the future.
Function, it's echoing. Hello, Thankachan?
Yes, yes.
Yeah, thank you so much, Mr. Thankachan, for all your creativity with special effects. Thank you to Mr. Anil Bakshi, our designer. I also thank our advisory board and editorial board for their continuous support and guidance for this initiative. Not to miss our young law students from various law colleges across nation and abroad and out who have volunteered for this initiative. Now, coming back to the topic of the day, I'm into mediation for almost 9 years and would certainly like to share my experience on crucial role of referral judges as a mediator. I'll be sharing a very practical example, an incident that happened in the courtroom itself. It was a court of a former judge, Justice Rajiv Bhalla, where he proved how crucial is the role of a referral judge in motivating parties. It was since he was holding a roster of matrimonial appeals. So it was a matter taken up when one of the parties was not inclined for mediation. So he, as a referral judge, tried to find out the reason for such disinclination, so that he can persuade and motivate them, in which he eventually succeeded. He further explained the concept, the process, and its advantages, and how, if settled, can satisfy their needs and interest. This has gone as a message in the entire courtroom because there are a number of lawyers sitting, litigants sitting, about mediation. And I'm sure that after that, because I left the courtroom, but I'm sure that number of litigants must have persuaded their lawyers to go for mediation, as they must have understood the benefits of mediation. Even in times to come, we can't think about mediation without judges. So now I call upon Punita Sethi, senior mediator of our court, to moderate the session further by inviting Justice Sandhawalia to have his ideas and views on the topic, and to further share her views being into mediation for last 12 years. Punita, over to you.
Am I audible?
Yes, sir.
Yeah,
Yes,
you're
sir.
audible.
Right, sir. A very good evening to our chief guest of today's evening, Justice Sandhawalia, all our patrons and all our dignitaries and all my friends. Being a mediator for almost 12 years, I have always strongly believed that mediation is the magic wand in the hands of the parties who are litigating but are totally unaware of it. And the process of mediation is nothing but a mode to remind them of their magic wand which they have in their hands. Coming to today's topic, role of referral judges in promoting the concept of mediation. As we all know that we are in a setup where majority of the mediators mediations are still court annexed, that is referred by the courts to mediation for resolution of the disputes. As such, the referral judges can very aptly be described as the strongest foundation which holds the process of mediation. In other words, the referral judges are the backbone of mediation and have a very vital role to play, which can largely be divided into two stages. Firstly, at the time of referral of the dispute, this is a very crucial stage and a very challenging one, as it is for the referral judge to make a choice as to which cases are suitable for mediation, because as we all know, all the disputes are not fit for mediation. The choice by the Honorable Referral Judge has to be objective and in tandem with the guidelines laid down by the Honorable Supreme Court in Afghan's case. To the choice for the suitability of the matters for reference to mediation comes an equally difficult task of preparing the parties who have been in an adversarial mode for years together to explain to them that they have an option to sit down together with a third neutral party, the mediator, and try and resolve their own dispute on their own terms, and explain the concept of mediation, the process, and its advantages. It is a very important step, as once this is done, it paves the way for a smooth process of mediation, ensuring the presence and participation of the parties in the mediation process, which at times is a cumbersome hurdle to be crossed by the mediator to get both the parties sitting across the table. The second important role of the Honorable Referral Judges would be after the mediation process is over, which again can be split into two parts. When a settlement has been arrived at in the mediation with the aid and assistance of the mediator, the same has to be placed before the referral judge, who would thereafter examine the legality and enforceability of the settlement and pass appropriate orders accordingly. If we are unable to reach any settlement, the referral judge would continue hearing the matter or explore the possibility of settlement between the parties again before hearing the matter on merits. We in Punjab and Haryana High Court have been very fortunate to have referral judges who have been and are progressively promoting mediation. We are fortunate to have today with us Honorable Justice Sandhawalia, who is also a member of the Punjab and Haryana High Court Mediation and Conciliation Committee for about more than 7 years, and he has been very supportive in promoting mediation. I would now request Honorable Justice Sandhawalia to please share his view on the topic of the day with us. Sir, over to you.
Thank you, Madam Punita Sethi. Well, first let me thank all three of you for putting us on this platform and the opportunity to interact at the national level in the comfort of the own home in these difficult times. But as we said, innovation is the need of the day, and therefore we have to carry forward. There are difficult times, but hopefully this bad year should soon come to an end, and everybody should be safe in their houses. Well, coming to my experiences, as Jane has also pointed out, I've had now a decent run with the committee as such for the last 7 years or so. And it has been a great learning experience, I must say. The learning experience or the curve is different as a judge or when I was a lawyer at the initial stage myself. Now I have been given the role to convince my brother judges to get them down to the mediation center, show them the facilities which we have, and the fact that the great infrastructure we have put in place, and to convince them that you should refer the matters and how we work on it. The learning curve, I would say, stems from the fact that as a lawyer myself, I might have had a different opinion about the role of mediators. But once you step across, then you realize that yes, how important they are in the system. Not only by interacting with the family of mediators, which is now almost 1,230 in the High Court, I must say that they not only have developed themselves as better persons while trying to resolve these disputes, because not only they have to psychologically understand the parties, but it also helps them grow. That how people like having such disputes, how they have to be tackled. This is a personal growth also, and the tricky job of the mediator of playing the balancing act as a trapeze artist, I would say, is always there till the end. If the dispute is resolved and the satisfaction of having crossed over a running river, I would say, and been successful to walk across on a thin wire. The advantages of the mediation we all know and has been laid down also by the Apex Court and AFCON's involvement. Now the important part, which my endeavor always is, by getting my brothers and sister colleagues to the center, that how we go around referring matters. It's very important.
Sir.
Because of my interaction with the committee and the center for some time, I am able to get an insight that is not just all types of cases which can be referred. A flooding of cases to the mediation center does not get us anywhere. The suitability of the case has to be seen. There is no point referring a very heavy session trials, disputes with the state, where serious criminal offences with general public are involved, or policies, questions of law, where there is fraud and fabrication, where minors' interests are involved. These cases are to be avoided, to be referred. So the court has a role to play, that what kind of disputes have to be referred. Now, cases which have the potentiality to be settled in mediation, I would say, are cases of contracts between developers, builders, landlord tenants, a supply contract, some consumer disputes, matrimonial cases in our court, of course, hog the main share. And I'm sure Madam Bonita Sethi will also tell us they constitute the majority of the litigation herein, but in other courts it might not be so. Disputes now out of Motor Vehicles Acts also are one set which need a proactive approach. The Apex Court in M.R. Krishnamurthy's case in the year 2019 has also recommended to set up a motor accidents mediation authority. We are all well aware the quantum of the first appeals, which we call them as first appeals against orders in this court, which is an appeal against the award of the MACT. The quantum of cases is huge, and at the end of the day, it's just a mathematical calculation, and the question of law is very rare in few cases regarding a license which might be valid or not. Majority is just a quantification which can easily be done through the process of mediation if we apply our mind. Well, we hope the government takes this recommendation of the Apex Court more seriously and sets up this mediation authority. It would be a great boost to mediation in the country. Now, the second step, I would say, is the stage at which the matter is to be referred by the court. This is also a very important aspect.
Sir.
The initial stage, as they say, when the iron is hot, that is the time to be done is when the parties firstly come to court. Of course, there is pre-litigation also now, mediation. But in matrimonial matters, courts dealing with restitution of conjugal rights or dealing with anticipatory bail applications should initially refer the matter, because at that point of time, the parties just need a patient hearing and it can be resolved. It is, if somebody is arrested, family members are arrested, feelings of humiliation come in, and then they're not willing to settle at subsequent stages. If in a landlord-tenant dispute, you can notice that once the tenant has been asked to deposit the rent, he would say that now let the litigation drag on, because he knows the law is also in his favor. And therefore, the resolve of what we call referring the matter to mediation has to be done at the first stage. What happens is, if we don't do it at this time and we lose this opportunity, you notice that they have gone through a certain set of litigation and decision making by one court. Lawyers have also stepped in to a very large extent, and therefore are also dependent upon their clients. And therefore, a lot of money has been already expended and time and valuable time is lost. So the second stage, which I would feel, is the stage of the first appeal, when the matter comes to court. That is also the right time, because parties have also realized how far they have reached by that time, and they know that there is a long journey yet. The third important aspect would be that the referral court has to make an effort to interact with the parties. The parties have to be aware that these reference is being done at the instance of the court, and the parties may have to be convinced also to this extent that it is the court which is in control of the mediation through the mediators, who are only agents of the court as such. And at this point of time, the court is also to assess the attitude of the parties, the advantages and the reservations, if any, they have. And it is at that point of time, the person who has such reservations has to be nudged and prodded in the right direction, I would say. The referral judge has to bring out the pros and cons of the dispute to the parties, and to the extent what delay can do to them, bring out the weak points also. One has to be mindful of this aspect, that parties are always given a very rosy picture of their case by their counsels, even if they might have a dead case, we can say. But the court has to kind of get a glimpse into the litigation and tell the parties that these are the disadvantages your case might have. And if you enter into a resolution, you might be at an advantage, because at the end of the day, in a court-mandated proceedings, he might not even get 25% of what he was hoping for, which through mediation he could, and with the help of the mediators, wrangle. The terms of mediation, the fact that it is free of cost, and that the refund of the court fees, all have to be explained to the parties before referring the matter. The parties would have to be explained that their mediators are only representatives of the court, and there is a process of confidentiality involved. And it is not that any agreement will be forced on their throat. They have to be informed that there is a fixed time limit with the mediators. And when the matter is to come back to court, and even if there's an opinion given by the mediators, that is not to waive the court. The fact that the time limit can be extended in case there's a request from the mediators is a fact which we all know. Mr. Jain would, Madam Sethi would also tell us that this court has prescribed a limit when the matters come back. How much is that, please?
Your Lordship,
So
initially,
90 days.
Sachin,
30 days, 30.
Your Lordship,
But-
initially is 60 days, extendable to 90, then again extendable to another month with the permission
Yes.
of the court.
So we do get requests in such manners that there is a scope as such that the mediation might be successful, and in such cases we do extend the time because it's our always effort as such that the result and the mediation process is carried through. Now, on an earlier occasion, the files would be sent to the mediation center, but it is not so because that is also mentioned in the judgment as we had talked about. The referral judge thus is under a duty to make a short order regarding the nature of the dispute which is pending. This only helps the center to allocate the case to the concerned mediators, who now also have built up the experience in different fields. Some might be well experienced in a landlord-tenant, somebody in the matrimonial side, somebody in child custody. So the center is also then well aware as what is the dispute regarding. The time frame is also as already fixed in this court, and in case there is a company or somebody is not represented in person and is an authorized person, then it is also mentioned that so and so is authorized, and under whom and by what authority. The important aspect is that referral judges should not be opinionated by any of the fact that the dispute has not been resolved. We are now well aware that it's not for the mediator also to record that on whose account the dispute has not been resolved. This only leads to a bias in the mind of the court, and it is to be avoided. Now, the Apex Court will also, in Motiram's case, issue directions that mediators are not to write anything. It's an interesting small judgment, but it says that the role of the mediator is to offer a proposal, a counter proposal, and nothing is finalized. It's just a contract in the making. And there should be, at the end of the day, only a one-line opinion that the mediation has been unsuccessful. The referral judges are also, again, as they say, the role never finishes till the matter is over. So, at the conclusion of the reference also, an effort should be made to interact with the parties and acknowledge their readiness to move forward in life and to resolve the dispute. Such a interaction only helps the litigants who have been successful in resolving their dispute. And they only promote and put forward the fact that there is a modem of dispute resolution within the court. Of course, now we have also advertising for a mediation center. We have a jingle on one of the FM channels. And I am told that there is quite a large number of people approaching the reference center, the pre-litigation also, which of course, I think is more first-hand experience because we do not get to interact with those set of parties. So Madam Punita Sethi would also tell us that this jingle is proving useful.
Absolutely, sir.
So
Absolutely, sir. Very useful.
It is on an FM. It just says that this is a mediation center is there, and you can come and approach if you have any problems. Summons are issued, and if the parties are informed. The person who gets in touch with the other side also keeps the other side abreast that this is not compulsive or there is no litigation, and matters are being resolved on this aspect also. Now, what is to be avoided by the referral judge is also another aspect which is to be kept in mind. That without calling parties, there is not a right to refer the matter to mediation. It does not take us anywhere. It is only after interaction with the court and after being convinced to some extent, the idea, as just now talked about, the idea of mediation has to be explained to them. So, in the absence of the parties being present, referring the matter at the outset to mediation does not really lead us anywhere, because most of these mediations do not, these cases do not fructify, and the disputes are very rarely resolved because parties just think that it is just, you gain time, go to the mediation center and come. These kind of disputes where parties want to delay have also to be avoided by the referral judge. That is another important aspect. That's why the time slot is fixed. The referral judge, apart from being opinionated, has also to avoid seeking any inside information from the mediator as to what happened and why and which party did not cooperate. And therefore, this is again based on the principle that mediation is a confidential process. And if the judge is to peek into the mind of the mediator and find out what happened, intercede the parties and the mediator, that knowledge is likely to creep in to the mind of the court and might also creep in to the order, which would be in contradiction to what the apex court has already held, that the mediator is not to give an opinion. So therefore, it would be worse for the court to form an opinion, because after all, it is a voluntary effort. Even in a failed mediation, the referral judge should not close the door totally. He can still find out. And where there is a little dithering or unwillingness on a part of the party, and if they choose to present themselves again, the court can always make efforts to push them through. Another aspect which is to be noted is the lack of references. They have to be, the percentage of success depends upon the number of cases which are referred. As earlier talked about, references have to be of a set of cases which can be resolved, but there has to be also the success rate also goes up if the choice of the right case is made. The types, of course, now have, as said, notice has to come for that now by matter of video conferencing, are we to carry forward? We've already received a request from the mediators on this aspect. I'm not sure how difficult it would be, but rather it's not very difficult. We are already holding court. It's not difficult for a court as such to refer the matter to a mediation. But the lack of interaction sometimes with the, as just now talked about earlier, we have to make an effort to interact with the parties. So that is the interaction. After all, it's just a meeting of minds. You try to peep into their minds. So by way of video conferencing, one could refer it. But the issue is that whether the mediators would be in a position to influence the parties by way of video conferencing. It would be, they have their hands cut out, their job cut out at that point. It's a very difficult job. And in the absence of the parties not being there physically, it will be a far more greater challenge. Well, we hope we can try to work on it, but as the situations are such that even entry to the High Court for advocates is restricted at this present point of time, we are hopeful that maybe this, if the situation continues like this, maybe even the mediation center might open its doors through video conferencing, but a decision would have to be taken in principle whether it is practical, possible, and feasible, workable. There are so many issues, and how, on what platform they will interact, that is also an aspect. If we do decide to, then I'm sure we will have to take inputs from all our mediators and suggestions how it is to be worked out. If this is done eventually, of course, it will lead to a lot of cost savings, the comfort from working from home, and tide over a lot of difficulties. I have always found that 24 hours are too less in a day. I can never try to catch up, and I'm always late. But the advantage of video conferencing is that you do miss the travel time, you sit at home, and you can do your work. So that is the advantage, I'm sure, the mediators also, and even the lawyers are now having, while arguing cases through video conferencing, sitting in their cool confines of the office and the house. Otherwise, in this humid weather, they would be running around in the corridors of the High Court and looking for air-conditioned courts to sit and dry themselves. So this is the advantage. If video conferencing, mediation can also be done through video conferencing, it would save a lot of costs. People could work from home. They would not have to travel. They would be able to spend more time with their families, and waiting period would be less. Recently, talk about my experiences with video conferencing and mediation. A matter was listed regarding a protection of a young couple. We have a lot of litigation on this aspect in our High Court, where intercaste marriages take place. People from rural backgrounds face humiliation at the hands of relatives, family members, friends, on account of choosing their life partners. So, the court had passed an order of protection, but was not able to interact with a girl who was just barely 19, who had opted to seek protection. The court was very concerned that it wanted to interact with the girl to find out whether she was safe with her new husband, and whether there was a kind of, whether it was not just a bondage. The presence of the girl could not be secured physically. The police was then asked to secure her presence through video conferencing, and with the help of the state, I was able to get her, interact with her through a WhatsApp call, along with the concerned police inspector and the police station. And it was nice interacting with the young girl, finding out whether she is safe and happy with her new marriage, whether it was an own free will, and whether the police was complying with the directions of the court. So these are the advantages, I would say, of the video conferencing, which can also be incorporated into the mediators also working with the advantage of technology. We all know that video conferencing initially was introduced in court process for the first time for the purpose of facilitating judicial remands. In the district courts, huge manpower costs is spent on this purpose to produce prisoners under trials in cases which are going on. So handling such persons is not only a huge security risk, but a huge infrastructure is required. Large number of police people and personnel are deployed. So video conferencing is one method to reduce these prisoners being transported on a daily basis to court premises, and the advent of technology and connectivity, which is now there, has led to an atmosphere where we can look ahead to better facilities and with the mediators striking to interact by way of video conferencing. Mr. Jain would put us and give us an example. I'm told that in a matrimonial matter, some parties abroad had interacted and settled the matter. Is that correct, Mr. Jain? I am told so. That
yes, Lord. Yes, Lord.
So, what was your experience?
Fact,
what was your experience if you were able to convince her husband who is sitting abroad to dish out some money for his wife and child, and your interaction on a physical basis? What do you feel? What is the difference as such?
So, as far as physical mediation is concerned, yes, it always have an upper hand on the video part, because once you see them, once you are face to face, you can get to know their body language, how they behave, how they react to things. But as far as on the video part is concerned, you can't make out, you can't judge, because there is somebody sitting next to them who may be a spoiled sport in the entire game. So that's physical is always good. Means I personally felt, but yes, in those matters, I could convince them. I can convince the husband to shell out about 70 lakhs for his wife and son who are in India. So I have a different opinion, but I still feel that physical mediation is far, far better than an online.
Yes, that you are absolutely right. There's nothing like a physical hearing. Nowadays, we are conducting court through video conferencing. But I would say that certain set of matters could be resolved by way of video conferencing. But contested matters where huge stakes are involved, it is difficult. It's only a little sketchy overview. And contested matters actually have to be heard through physical hearing. That is the only way out. We cannot lose sight of this. Another important question which always comes up is, for the referral judge, I would say, is that once a settlement is arrived at between parties may tend to back out, and some parties may have altered their position also in terms of the settlement. Now, it's a very moot question, because the court has a responsibility as it asks the parties to get into mediation. And therefore, it also has a responsibility to ensure that no party suffers any loss because of a party backing out. But then on the other hand, since it is a mutually resolved method, it is to be kept in mind that we cannot force a settlement. So the court then has to do the delicate balance to make sure that if any party has any advantage, taken any advantage, whether it's monetary, financial, taking possession of some properties during the course of settlement or as per their terms and then backing out, then it is the duty of the court, I would say, to put back the parties at the same stage when the matter was referred to mediation, as no party could take any undue advantage and gain from the court having referred the matter. The duty of the court also, while it interacts with the litigants, is that the interaction should be in the mother tongue. A large number of people come from different backgrounds. They might not be comfortable spoken to in a language they're not able to correlate to. We have a lot of mindset if a person is interacting in a different language. We all are aware. English is looked down by on account of persons who have not been able to get the same kind of education, or by people who are more fluent in vernaculars. English-speaking persons sometimes look down upon persons who speak in vernaculars. But this is a normal perspective of life. Therefore, the effort of the referral judge also, and also I'm sure of the mediator, is also the same. That once we have to interact, it has to be in the mother tongue so that the party does feel comfortable. Now, we can have a little bit of interactive session also, I would say, that what more do you feel that needs to be done on the end of the referral judge? We could take Madam Jalota's opinion at the start.
Sir.
What, Madam Jalota, what do you feel is that something more than as discussed, some another point which we have missed out? How do we work out on that while referring the matter? Or what is lacking and how we can improve?
Madam Jalota, please unmute yourself.
Thank you, my lords. I was actually muted by the host, so I could not unmute myself. I'm so grateful, my lords. My lords has very greatly laid down all the things which my lords has said are very correct. In VCs, the only thing I feel is that the confidentiality part is very important, which is to be taken care of. In VCs, one party can record the part of the other party, and that can be a problem. But when we start with this ODRs, the way we are told,
you're very right. Yes, in video conferencing, anybody can be recording proceedings and then later on confront each other. That is a very, very sensitive, I would say, a very sensitive issue. You are right, because even in court proceedings, we are not sure that sometimes court proceedings could also be recorded, and it is maybe, yes, it's a issue which needs consideration. You are absolutely correct. Yes. What suggestions more would you have, ma'am? I think she needs to be unmuted again.
Muted again, probably, Your Lordship.
Yes. Yes, Madam Sethi, you could also
unmute yourself.
may I please, my lordships? My lords, the way we are progressing in the video conferencing in the courts, the same way when we will start ODRs, we can, because we can do the conferencing on the secure lines of the High Court. One can be this suggestion. And the other suggestion is that certain centers in Bangalore are following, and elsewhere also in India, that there can be a contract between the parties. They have to sign an agreement that they will not be recording. So these things, when we will start, we will be able to by find solutions about it, Milods. Thank you.
Yes, Madam Sethi, you have some.
Sir, I would like to add here that
Yes.
as far as family disputes are concerned, where emotions are involved, may it be matrimonial disputes or the family disputes, there the VC mediations, we do have a soft this thing there, because it's not very successful, because the body language and at times the physical appearance, once they are sitting across the table sharing the emotions and everything, as far as the family matters are concerned, of course, the normal mediation process was far more better. But as far as the commercial matters and other contractual matters are concerned, Your Lordship, there we see with, as Madam Jalota had said, a few of the centers are following the signing of the contract and all, where no emotions as such are involved, and it is basically just commercial transactions. There VC is a very good option, Your Lordship.
Yes. You are right. Nowadays, as they said that with a mask on, you cannot come to know what is the expression on the face. So therefore, for a mediator not to know how the party is reacting with a mask on, it is almost impossible. And the body language and how to conduct yourself with a person physically is a totally different. It is a different feel. You are able to gauge the reactions of a party much better if a person is physically present. There is no doubt about that. But you are right that in commercial types of litigation, one can have a feel as such of video conference. Yes, Mr. Jain, would you have some suggestions over and above what your colleagues have?
So I would certainly take Madam Push Gupta on line, because she's the first person who have done e-mediation, online mediation settled, referred by a court, and I think she'll be a better person to share her views on this topic. Mr. Thankchan, could you please unmute Madam Push Gupta?
Yes, already unmuted.
Madam, your views
Yes, I
on
unmuted.
Madam Push?
Yes, thank you to share my opinion. Yeah, my views. I must first thank you, Mr. Honorable Mr. Justice Gurmeet Singh Sandhawalia ji, for acknowledging the presence of this initiative and sparing his valuable time to guide us through as to the important my view is cannot in
I think we have a very poor connection from Madam Push Gupta. We are not able to really make out. So it's surprising how time has flown by. It seems that we have spent an hour together, and it seems that we now must sign off. But before I sign off, I should be thanking Dr. Sri Kumar Jain, who has also contributed to this third chapter as Mr. Pradeep Devan, senior advocate. He has also added to this third release, Mr. Mark Clow and Mr. George Merlo, Mr. Krush P. Anthony, and Madam Kiran Bhardwaj, Mr. K.S. Sarma, and of course, the evergreen Mr. Chandok, I believe, have contributed to this third edition. So I must congratulate them too, and I would like to get my hands on all these compilations, which Sachin Jain will ensure that I have by tomorrow. So with the above discussion, I again thank you for a lot for letting me in this interactive platform, and which I hope the mediators become used to in the long run. All of you take care. Thank you, and take care in the tough times and remain safe. Bye-bye.
So
Thank
I
you, sir.
would
My
now,
Thank
lords,
you
I
so
will
much, sir.
request you to wait for 2.
Your Lordship has explained the process so well and elaborately that we perpetually all our questions have been answered, Your Lordship. So we have no more questions to be asking Your Lordships. And with that, I would request my fellow mediator, Madam Monica Julota, to please share her views, if any more, and propose a vote of thanks. Over to Madam Julota.
Thank you, Punita. Namaskar. A very happy evening to all of you. Happy and knowledgeable this Saturday evening is. Happy because being in our this August gathering and among us all our mediators, ever affectionate mediators family. It gives immense happiness. And knowledgeable due to the pearls of wisdom shared by my Lord Mr. Justice Sandhawalia. The topic of the day, role of referral judges in promoting the mediation. This topic touches the concrete foundation of mediation in India, which was initiated on this platform on the basis of this foundation and is progressing because of this topic only, the role of referral judges. See, the court annexed mediation has its genesis in the referral judges. So this topic holds a very concrete foundation for the mediation in India. So whenever we talk of mediation, we have to have the referral. And when we have to have the referral, we have to have the very promoting referral judges, which can promote mediation by sending more and more cases to the mediation. I now take the permission of all to little broaden this topic to the role of judges as such in promoting the mediation. In addition to the referrals, the judges has vehemently promoted the mediation by organization of various training programs, refresher courses, advanced courses, and so on at the various junctures, and also by actively participating in mediation activities. The presence of my Lords Mr. Justice Sandhawalia today evening is the perfect example of it. My Lords was busy doing the VCs throughout the week, but still he found a time and give us his enriching words on this evening, Milords. We are very thankful for that, Milords. And in fact, when we talk of the role of judges, we can well visualize the setting up of the mediation centers, selecting the mediators, and getting the infrastructure on whom it is dependent. It is all dependent on the judges. So mediation in India is thriving because of the patronage of the honorable judges at all levels, which helped the mediation to have firm footing in India. I still remember the day of May 2008 when my Lord Mr. Justice S.B. Sinha, Honorable Judge of the Supreme Court, he came to Chandigarh. He inaugurated a conference. It was a regional conference at Panchkula Indradhanush Stadium under the aegis of Mediation and Conciliation Project Committee of Supreme Court, where we first came to know about mediation. From there on, it has been 12 years. And this 12 years of journey has been full of many beautiful moments. But all my beautiful moments will also be filled by the patting on the back by the judges to the mediators and the mediation process. So the role of judges is to the extent that the mediation thrives on their patronage only. So I will also now say that now after this time of period in India, the mediation has entered in teenage. And as we all know, teenage is very energetic. But at the same time, in this age, the guidance of the elders is very necessary. So here I will be referring to the honorable judges. Their guidance to us is ever more important in the teenage. The need of the hour is to keep a vigilant eye on the ethics and conduct of the mediators, and also to induct more and more passionate and dedicated mediators in the mediation family, so that the mediation can establish itself as the most dependable and responsible dispute resolution mechanism in India. I thank all the judges of the Honorable Supreme Court, judges of the Honorable High Court, and the District Judiciary to repose trust in us, and also look forward as a family of mediators, as a mediation family. I look forward for their guidance and blessings to our journey onwards ever. All other things about the referral judges has been very elaborately already said by the earlier speakers. So now I will move on to the vote of thanks. Lords, with your permission, and now I propose vote of thanks on behalf of E-Mediation Writings family. We express our deep gratitude to Honorable Mr. Justice Gurmeet Singh Sandhawalia for gracing this occasion and releasing the third edition of the EMW, and also for enlightening us with his valuable words. Thank you so much, sir. Thank you, honorable patrons, the members of advisory board, the editorial board, and the state coordinators of E-Mediation Writings for granting an opportunity to Punjab and Chandigarh chapter to organize this webinar. Big thanks, a very big thanks to all the participants. On screen, I can see Honorable Mr. Justice K. Kanan, former judge of Punjab and Haryana High Court. Our master trainers, Dr. Sudhir Kumar Jain, Mr. A. Jawad, trainers, senior mediators, mediator advocates, students, state coordinators, young volunteers of the EMW family, and all others for joining us today evening. Special thanks to Mr. Thankachan, our key creative head of the family. He has created such a beautiful things. So a special thanks to Mr. Thankachan, Mr. Anil Bakshi, magazine designer, our technical team, and my teammates, Mr. Sachin Jain and Ms. Punita Sethi, without whom this event would not have been possible. And dear Kush, how can I not say thank you to you? A very big special thanks to Madam Push Gupta, whose idea has blossomed into E-Mediation Writings, the first of its kind of endeavor in India. I am grateful to all of you to join us on this evening and make it more and more happy and special. Eid Mubarak to all. Please stay safe, take care, and we meet on 1st of September for release of the 4th issue of EMW edition. Now I hand it over to Mr. Thankachan for the closing ceremony.
Yes. So, with your permission, let me conclude our session, and thank you for all participating in this wonderful program. Thank you all.
Thank you, sir. Thank you, sir.
Thank you, everyone.
Thank you so much, sir. Thank you.
Thank you, everybody. And the only complaint I have is that I am not able to see the other members who are participating, including Justice Kannan. But I'll catch up with them on a personal front. Thank you. Good night. Happy Rakhi also.
Thank you so much.
Thank you so much.
Thank you.
With
Thank
your
you so
permission,
much. Thank you.
So let me conclude it, sir.
Thank you. Thank you all. Thank you. Thank you, everyone. Thank you.
Thank you, madam. Thank you, madam, for making us a part of this wonderful chapter.
Thank you. Thank you, everyone. Thank you, Sachin, Punita, Monica, Mr. Thankachan, and everyone of this part of this. Thank you so much. Thank you, Vijay. I can see you there. Thank you. Thank you.
Okay.